Third case on this morning's docket, case number 109353, State of Kansas v. Williams.
Mr. Williams appears through counsel Michelle Davis. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
This case proceeded to trial, and it was not contested that Mr. Williams had been the shooter. The issue at trial was that Mr. Williams argued there were mitigating circumstances or that he had acted in defense of another. So that was what the trial focused on. And so the first two issues in the brief go to that issue, to Mr. Williams' state of mind at the time that he fired the shots. And so both issues regard two women who had reported that they had been victims of the deceased. And the trial judge did not allow one of the women to testify about specifically what had happened, because the judge said it was inadmissible character evidence under the statute. And our claim, and the claim of the trial counsel, was that this evidence was admissible to show Mr. Williams' state of mind. That Mr. Williams had testified that he, at the time he fired the shots, that he was afraid and that he was scared. And
was there
to support that, the reason why he was so afraid and he was so scared, because he knew that how Putnam had treated these other two women.
So there was testimony that at the time of the shooting he was aware of these two prior attacks?
What defense counsel proffered was, and I can give you the cite on that, it's volume 12, page 47. Trial counsel proffered that he's aware of Mr. Putnam's actions, that being the defendant was aware of the deceased actions, and this was in the proffer, the argument trying to get the court to allow the woman to testify about specifically what had happened. And trial counsel also said it goes to his state of mind. So, and then the other part of the record that supports that he was aware was when, at the motion for the new trial, when the investigator testified that Mr. Williams had reported that the deceased had attacked these two women, and that's why the defense was looking for one of the women. So there are parts in the record that show that Mr. Williams had this knowledge.
Is there anything in the record that would indicate that the defendant had that knowledge prior to the shooting?
That would be just both of them do, because the one is the counsel saying he was aware. We want to bring this evidence in because he was aware of it. And I'm assuming he's meaning at the time of the shooting. He didn't use those words literally. And then the fact that, well, I guess the second one doesn't. The investigator saying we were looking for these women because of what he reported. And then the fact that the defense is saying we're asserting defense of another.
So at least with respect to the investigator, clearly they knew that these allegations were out there. That's why the investigator was looking for them. But that certainly, there's no indication. In other words, it doesn't necessarily follow that means the defendant was aware of it prior to the shooting.
Well, it does, because that's their defense, is I'm acting in defense of another. And so there's a subjective state of mind component to it. And then also in the proffer, counsel saying he was aware, and we're using this to show his state of mind at the time of the shooting.
Okay.
So it's not directly there, but you can piece it together. And so it's our contention that with the woman who was going to testify that Walters is clearly on point, that the evidence isn't being offered to prove the victim's character, but to prove the defendant's state of mind. And so the court erred in not admitting the evidence. There's a difference here. The state's arguing, well, she got to come in and say her opinion is. She can offer her opinion that he can become violent in an instant. But there's a difference between offering your opinion and being able to give specifically what had happened and how he had acted on a specific occasion, and being able to give more details about what had happened. And then the trial court's ruling saying you cannot specifically get into what had happened also prevented the defendant from testifying about what he knew, about what had happened, because of the court's ruling. So that's one issue. And then the second issue, the motion for new trial, the state's failure to disclose information about the second woman, the defense also wanted to admit that evidence for the same reason. And the issue here is that,
Can I back you
Yeah.
up just for a minute and just ask a question about the record? Is it clear that the court's ruling covered the defendant's testimony as well?
well,
I mean, was that issue specifically addressed by?
well, the
during-
judge has said, by statute, you can't bring this evidence in because the statute prohibits it. Any testimony about specific instances of what the deceased had done, specific instances of conduct. So, I mean, I would draw that inference. You're right, it wasn't specifically raised. Defense counsel didn't say, Judge, I want to ask the defendant this. But I think the judge was pretty equivocal in his ruling,
Okay.
that the
I just-
statute didn't allow that evidence. But no, defense counsel didn't try to re-argue that before the defendant testified. But I only said that because the state's claiming that in their brief. That because the defendant didn't try to talk about this, that therefore the defense didn't somehow that is to be held against the defense. But I
Kind
think,
of a preservation kind of argument, or?
well, I think it's kind of hard for the defendant to talk about it when the judge has said this isn't going to be admitted. And then it doesn't matter even if the defendant does try to testify about it. Well, I knew or I had heard that he had tried to do this on this occasion. I mean, it's hearsay because she can't testify about it. How's the defendant going to testify about it? So, on the second issue is that the detectives in both cases knew that the deceased had apparently, there was a friend of the deceased or associates of the deceased. There was a case where he had tried to shoot or had shot at the house of one of the women. And so there was a second case involving this. And that the detectives in both were aware of both cases. So they were aware that she had filed this police report alleging this attack by the deceased. That there was this other case going on where an associate of the deceased had then shot at her house. And that the prosecutor in the other case knew also about these connections and that none of this was disclosed to the defense. That she had filed this police report and that she was in custody and that there was this other case going on. And that the failure of the state to disclose it may have been inadvertent, but that it was material and exculpatory evidence because the defense could have used her. They would have known where to find her when they couldn't find her. But also it made her, that this was an accurate version of events, that she had filed this police report, and it could have led to some further exculpatory evidence. And the state, in their brief, is trying to say, well, that's not fair because they didn't know that what the defense was going to be here. But it's pretty clear that the state knew what the defense was going to be because the state tried to file a motion in limine pre-trial trying to stop the defense from bringing in prior instances of conduct by the deceased as it related to the defense. The state knew that this was going to be the defense.
Go ahead. Basically, what all this leads up to is the defense is trying to posture a case where you get a voluntary manslaughter instruction. Is that right? I mean, based upon the fear, the provocations, isn't that what this is leading up to?
Well, that was one of the issues that the defense had wanted a heat of passion.
Well, I mean,
provocation
why is
defense.
it relevant other than to show that? I mean, what the behavior in the past of a victim is, why is that relevant other than to show some sort of state of mind in which you believed I needed to exert deadly force to prevent something from happening?
Right, that's right. I mean, it did go to his subjective belief that he had acted in manslaughter. And that was really the defense here. There were mitigating circumstances, that it was not premeditated, that he had fired. He testified that he really couldn't tell you what he was thinking, that he just acted, that he was afraid, that he was scared.
And all that was based upon some of that, at least according to his theory, was based upon some of this prior conduct.
Right, that's why he was so afraid of this man.
But isn't the focus of a voluntary manslaughter instruction what the facts are as they arise from the occurrences they are then, or fairly close to that conduct? In other words, it's not, you don't go back years and look at what the victim may have done in the past, but you look at what the circumstances are, the present day circumstances, and
Yeah.
and why is there factually a voluntary manslaughter instruction warranted?
Well, there's two parts to this. The evidence went to the self-defense voluntary manslaughter part,
Right.
in terms of his subjective state of mind. The instruction that was refused was the heat of passion, sudden quarrel, voluntary manslaughter instruction. And defense counsel wanted that because of the testimony that the defendant said he fired the shots because he was trying to pull her
Right.
away. And then that's when he fired the shots. And so he got involved. Trial counsel said this is evidence that he got involved into this quarrel between these people, and then that he then got involved, and that this had been a passion type of event. And then there was also testimony from other witnesses that rather than being self-defense or defense of another, that this had been more of a quarrel provocation situation, where he said he was angry. The defendant testified that he was angry. So it's our contention that the evidence really supported both forms of voluntary manslaughter. So in that regard, I guess I'll jump over to that issue, but I think the only thing I want to add about that is interesting on the voluntary manslaughter instruction is that we argued for the harmless error standard that should apply, should be the constitutional harmless error standard. And the argument on that is that because the defense had requested the voluntary manslaughter heat of passion instruction, that basically the defense wanted to assert voluntary manslaughter heat of passion as a defense, and it as a mitigating circumstances being our defense. And that because it was an instruction requested for a defense of mitigation, that the constitutional error standard should apply. And the state, I think, tries to argue something about that, well, the defense didn't really argue this wasn't their really theory of defense, but it's a little hard for trial counsel to argue this in closing argument when he doesn't get an instruction on it. I mean, I'm sure that trial counsel in closing would have argued this. This could have been, he could have acted in defense of another, or he was just they were caught up in this quarrel and he just acted out of passion rather than reason. But if you don't get the instruction, it's a little hard to argue it. That would conclude my comments unless there are questions.
Any more questions? Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Beginning with issue 1, I think the first point that I want to make is one that is very obvious and this court's well aware of, but I think it's critical given the argument that's been raised here. It is always the appellant's burden to designate a record that affirmatively shows prejudicial error. And I would argue that in this case, the defendant has not done so with respect to the first and second issue. Specifically, our position is that there is nothing in the record to affirmatively show that at the time of the shooting, which is the relevant time, that the defendant at that moment was aware of the alleged attacks that the victim had committed against Melanie in issue 1 and Christy in issue 2. Undoubtedly, there is evidence in the record that the defendant knew about these alleged attacks before trial. That's clearly not contested. I'm not suggesting otherwise. But what's relevant is the defendant's state of mind at the time of the shooting. And I think to answer or address an issue that Justice Rosen was talking about, based on the way it was argued below and in the brief, the first two issues are relevant as to the defense of others, not so much as to the voluntary manslaughter, heat of passion, sudden quarrel. And when you look at the defendant's brief, it's clear that they're arguing that the defendant's ability to present this testimony about the attacks on these two women is relevant because it would weigh on the defendant's subjective belief at the time of the shooting, and whether that was then would have assisted his defense of others' claim. I do not find anywhere in the record in which there is affirmative evidence that the defendant knew about these alleged attacks at the time of the shooting. With respect to Melanie testified when she was testifying outside the jury's presence as a proffer. What she indicated was that this alleged attack occurred in the victim's bedroom with the door closed, that she and the victim were the only two people in there, and that the alleged attack stopped when the victim heard the defendant enter the home, not the bedroom. She also said that the victim told her not to tell anybody. I think he threatened her that if she did tell anybody, he would harm her. She never testified that she did tell the defendant about it. She didn't testify that the defendant entered the bedroom itself. She didn't testify that there was any other indication that the defendant independently learned about this alleged attack. The defendant, meanwhile, did not offer a proffer. Counsel mentioned today what the defense attorney told the court he anticipated the evidence would be, but that's different than the defendant actually getting up there and making a proffer. And I would point out to the fact that when you look at the defense counsel's proffer and compare it to Melanie's testimony, there were differences in what the defense attorney said Melanie would testify to and what she actually did. I think the defense attorney indicated that when this alleged attack started, the woman said that the victim was asleep when she first entered his bedroom. Well, when Melanie herself took the stand, she indicated that the defendant was not asleep. So the fact that defense counsel might have said something is not of evidentiary value when the defendant chose not, for whatever reason, chose not to make a proffer himself and testify outside the jury's presence and affirmatively say, yes, I knew about this shooting not only before trial, but I knew about it at the time that I shot the victim. Absent any evidence, specific evidence, that he was aware of this alleged attack on Melanie, it possesses absolutely no relevance. Again, the only reason that the defendant is even trying to assert that it's relevant is to the defendant's state of mind. Clearly, something that he is not aware of cannot affect his subjective state of mind at the time of the shooting. And for that reason, it's not relevant and it was not admissible.
Can I clarify? So you're saying then that the proffer that counsel referred us to earlier was a proffer of what defense counsel thought the MM would say?
The majority of defense counsel...
And make sure you understand what I want to focus on there is the part of it that says that he was aware, meaning the defendant was aware of the incident.
Right. And looking through my notes, I did not find that exact quotation, not to say that it's not there. So I can't speak in detail to exactly how that was phrased, but I would ask the court when reviewing the record for that to look carefully as to whether defense counsel was specifically saying that his client was aware of it at the time of the shooting or whether he was simply saying he was aware of it before trial. Much as and this goes into the second issue, where at the testimony on the motion for the new trial, the private investigator clearly testified that the defendant was aware of the allegation against that Christie made before trial, and that's why the defense was looking for this witness. But the investigator never indicated that the defendant was aware about Christie's allegation at the time of the shooting. So I'd ask the court to look at that carefully, and to the extent that counsel did say that the defendant knew about it, first I would question whether counsel's statement really constitutes any type of evidence in the case or even a proffer when the defendant did not personally get up and testify, but also whether he really was indicating that affirmatively that the defendant knew about it at the relevant time. Again, if he was not aware of it at that point, then even by the defendant's own theory, I don't think that there's any argument that it was otherwise admissible. I would also note, just to touch on the fact that the defendant's raising this as a denial of his constitutional right to present his theory of defense, even though Melanie was not allowed to testify about the specific instance of conduct, she was able to testify in general about the victim's reputation, and she specifically testified that the victim was a nice guy until he didn't get his way, and then he would turn into, quote, violent and rape guy. So clearly the theory of defense was offered. The defendant was able to offer that, and I would argue that in some ways it's even more favorable for the defendant to have a witness that's testifying that the victim apparently has done this type of thing so often that it's his general reputation. It's not just a one-time deal. This is his reputation. He does this. This is his persona. This is what he is. So I think that clearly the evidence came in that way. And the defendant also was able to testify that the victim was attacking his wife at the time. So this is not a situation where the defense was prevented from presenting the theory of defense. This evidence, consistent with the theory of defense, was allowed insofar as it was appropriate. It was excluded where it was not. Furthermore, as a backup argument, I argue that any error would be harmless. When you look at the, first of all, I would note that the defendant, when he testified at trial, he never mentioned the proclivity that the victim allegedly had for violence against women in his explanation for why he shot the victim. He mentioned the fact that he was concerned because he knew that the victim had been a law enforcement officer and that he was well trained, and I think he said that the victim had even bragged about how many people he had shot and killed. And so even by the defendant's own testimony, he was not talking about, I shot because I was scared that he was going to do something because he had a history of harming or threatening women. It was, this guy was a law enforcement officer, he was a trained shot, and he had shot so many people that he was no longer allowed to be a police officer. I'd also note that, of course, in all of his pretrial statements to other individuals, the defendant never mentioned this alleged attack on his wife at the time that he explained the shooting to various people. In addition, Weiss herself, the defendant's wife, she gave an account of the shooting to a friend and said that it was over an argument that the defendant and the victim had over a drug deal. Also, in the days before the shooting, the defendant had made statements to multiple people indicating, in one instance, I think he specifically indicated that he wanted to kill the victim, and in another instance, he said that he wanted to get rid of the victim. So when you look at all of the evidence in its entirety, even if the court somehow concludes that this evidence should have come in, its exclusion was harmless. Turning to the second issue, and I'll probably sound like a broken record here because the argument, the analysis is very similar. Again, there was no proffer that the defendant was aware of this alleged attack on Christie at the time of the shooting. All we know is that the investigator said that the defendant was aware of this alleged attack before trial, and that's why the private investigator was looking for this woman. But that's not relevant. It doesn't matter if he found out about this alleged attack sometime after the shooting and before trial. That has no bearing on his subjective state of mind at the time that he pulled the trigger. Second of all, I would argue that the state did not suppress this evidence because, simply stated, there was absolutely no way for the state to know that this was relevant to the theory of defense. Arguing otherwise, what the defendant has argued is that various pretrial motion filings essentially should have tipped the state off that this was going to be the theory of defense. But when you look at those motions and the things that the defense is citing, they are things that just as easily could have been interpreted by the state as a self-defense claim, as a defense of others claim. There was no specificity in it. The state never had any specific notice that the defendant was going to argue that he shot the victim because the victim was attacking his wife and because the defendant knew that the victim had previously done similar things against other women. As our attorney argued at the motion for new trial hearing, the defense clearly is entitled to play their cards close to the vest. They don't have to tell us in advance of trial what their theory is going to be. But if they don't tell us that, they then cannot come back after the fact and say that the state somehow should have guessed that this was going to be the claim. Clearly, in every murder, in every situation like this, the fact that the victim himself might have been alleged to have done something improper in his past is only relevant insofar as it does touch on the theory of defense. And again, without any indication that the defendant was going to raise this theory of defense, or that he knew about these attacks, he cannot meet that test. Furthermore, again, I would argue that...
Let me clarify that.
Sure.
The fact that the victim committed a violent sexual attack on someone else would be evidence that a defense attorney should know. Wouldn't you agree? Whether they develop it into a theory or not,
I would suggest not, certainly not in every case. Let's take an example of somebody that goes into a convenience store and holds the store up and robs a perfect stranger, and in the process of that event, shoots and kills the store clerk. This is somebody that he's never met before, no history with this victim, just goes into a store and kills somebody. Well, if the prosecution is aware that days, weeks, years before that store clerk had sexually assaulted somebody, I have a hard time seeing how there's any relevance at all that would come into a trial like that, absent some indication that it weighs on some element of the offense or on the theory of defense. I don't think that the state has a duty to turn over everything negative about a victim in every situation. Clearly, in some situations, it would be warranted, and I think this case could have been that case if the state knew that this could have been the theory of defense, and if there was an indication that the defendant, in fact, was aware of that. But I don't think that just because somebody's on trial for murder, that means that everything that's ever been alleged against the victim is automatically...
Weren't you aware that was going to be a potential theory of the defense at the time Mr. Williams made his statement? Isn't that what he said occurred, that he saw his wife being assaulted and he took action at that point? I mean, isn't it pretty clear that's going to... high probability that that's going to be a defense?
The first time that came out was in his testimony itself. It didn't ever come out before trial, and even in the defense counsel's opening statement, there was never any type of comment that was that specific. It was in the testimony itself where that came out, because again, the defendant spoke to numerous people. He was more than willing to speak to various friends and acquaintances about what happened, and he never gave this version. And when he first spoke to police, before they even knew that the victim was dead, he lied and said that the victim had simply packed his belongings and moved, and that he didn't know where he was. And then when he was formally arrested, he invoked. So he never gave a statement to law enforcement after they knew that the victim had in fact been murdered. So the first time that this ever came out and was developed was in the defendant's testimony itself. I see that I am out of time. I would just wrap up by again arguing that our position is that with respect to both issues 1 and 2, there was no relevance because there's no affirmative indication that the defendant knew about either of these assaults at the time of the shooting, and that's the only relevant time. I will submit the remaining issues on the brief unless there are questions, and would just respectfully ask that the defendant's conviction be affirmed.
Any more questions? Thank you, counsel.
Well, I would just again refer this court to the record. And I went back and looked at it while I was sitting there, and it's pretty clear that trial counsel says we're trying to show his state of mind at the time of the shooting. And he was aware of Mr. Putnam's actions at that time towards this woman.
Where is that in the record?
That's volume 12. Look at the very top of page 47. That paragraph, he specifically says on December 16, his state of mind on December 16 because of what had happened on December 12. And that was the incident with the woman and Putnam.
And that's
He
at page,
specifically says that.
page 47, you said?
Right, volume 12. And I mean, you know, defense counsel has some intelligence when he's saying we're asserting a defense in his subjective belief in defense of another. I think everybody's talking about it the night of the shooting. I think, so anyway, I would just refer you to that. And then the stuff about the state had no knowledge of the defense prior to trial just isn't correct. There's a witness, Sherrard, who told the detectives that Mr. Williams had told him the shooting was connected to an incident with his wife, that there was a quarrel. Sherrard told detectives that Mr. Williams said that he shot Putnam because he had done something with his wife. I mean, and you're talking about one of the incidents, the rape report took place in like January, and then in March, there's this shooting where the victim is shot at. Putnam, she's alleging Putnam's her attacker, and then in December, Putnam shot. I mean, talk about something a trial counsel will want to know. Who has a motive to kill Putnam? I mean, he's a victim in a case, and he's a perpetrator in another case, and they don't think it's necessary to share that with defense counsel? That your victim has been attacking other people and is a suspect in this other case? So I mean, you know, in hindsight, you can say since he admitted being the shooter, but before trial, it certainly would have been very relevant to his defense. And then the part about, well, the evidence of premeditation is strong because he said he was going to kill him. Well, that came from the gentleman Walker, who was incarcerated, who was trying to get a plea deal with the state, or a deal with the state for a lesser sentence, and he came to trial and he recanted. He's the one that said that Mr. Williams had talked about killing him, and he just recanted all of his statements. I mean, his testimony was incredibly, or his statements to police were incredibly suspect because of his motive and then the fact that he recanted them. So it's our position here that the evidence of premeditation isn't strong. That this is a case that if evidence had been presented, the jury would have had sympathy for Mr. Williams. And there is a real possibility here of a verdict for voluntary manslaughter.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.